there's so much to lose if you do something wrong, because it is quite daunting. There's so much that you take in, especially if it's your first commercial property purchase. Very different to residential. Residential is emotions, helping people build assets, build wealth. How does this look? How does this feel? But commercial properties, numbers, does this work? Am I protected? Is this the safe purchase for me? The devil's in the detail, and it's when you come back and have to deal with a $50,000 issue down the track, or a $100,000 issue that you could have just had resolved earlier on and paid maybe $2,000 or $3,000 or more in legal fees up front. Then you realize the value of a good lawyer. Yeah, or throughout the process, some people will just say, well, like, we didn't really hear much from you. Like, why is this so expensive? But the reason why you've not heard much is because everything's been dealt with behind the scenes. If I copied you into every single email, every single call that we had, and you'd lose your mind for the amount of communication there is. Yeah.
G'day, how you going? Phil Tarrant, co-host of Inside Commercial Property, flying solo today without Scott O'Neill. Today, very serious conversation around property law, and you might sit there right now and go, I don't want to listen to that and turn it off, and I don't want anything to do with law. And I know a lot of people think that and feel that, and I sometimes have too many lawyers in my life and I want to get rid of them. But when you need a good lawyer, you certainly need a good lawyer. And if you're investing in property, you need to ensure at the front end you get the legal side of things right. So we're very privileged to have Sam Saad in the studio today. He's managing partner at Rethink Property Lawyers, works very closely with the team over at Rethink Investing. I've used Sam myself for commercial purchases in the past, and today we're going to get stuck into everything property law. This is the pointy end of assessing and due diligence, and you would have seen and heard our last conversations where we broke down the due diligence process. A big aspect of it is property investment is finding the right property and ensuring that's right for you and meeting your needs and your strategy. The other side of the equation is ensuring that everything around that property is right and the efficacy of it is sound, and all the relevant connected aspects of it have been checked thoroughly, and you can proceed with confidence as part of your investing decision making. And you need a lawyer. You can try and do this stuff yourself, and good luck with it. I've tried it beforehand. It's a miserable job. If you don't know what you're doing, you've got to find someone who actually knows what they're doing, enjoys what they're doing, and actually is very good at what they're doing. And certainly Sam and his team are part of that. Sam, how you going? Good to see you, mate.
Good, thank you, mate. It's good to be back.
Sorry to beat you up. I don't really like lawyers. So,
no.
Yeah.
Not many people do, and
No.
they only need us on a needed basis.
Yeah, I do joke. I think I have a lot of respect, professional respect for lawyers. You do an exceptional job, and when you need a good lawyer, you want to make sure you got a good lawyer. And the best lawyers I know set you up so you never need a lawyer into the future.
That's true.
And a good lawyer will do that. But when it comes to property law, specifically around commercial property purchases, can be complicated, complex. There's not only the assessing the opportunity itself, the property, but it's the long-term viability of that and everything connected with it. So, lease negotiations and everything therein. So we're going to get stuck into all of that fun today. How did you end up in law, man? Like, what's the story?
I've always wanted to be a lawyer since I was a kid. Most people say it's a cliche, but since I was 5 or 6 years old, people would say, what do you want to do? And I'd say, I just want to be a lawyer. It was a prestigious thing, still is, I hope. And there wasn't as many lawyers around back in the day when I was younger, but everyone knows a lawyer these days. So
I can't believe you wanted to be a lawyer when you.
Yeah, I know. And then Suits came out, and that confirmed it.
Oh, you just watched it, you binged it.
Yeah.
So did you have any? How did you know about law if you were a young kid? Like, what was the sort of influence there? Was it just TV shows and stuff?
Yeah, look, sometimes my parents my dad was in business a lot. And so, I always remembered lawyers were always highly spoken of, and, it was always such a cool thing going to when your parents had to go to lawyers and you'd come with them, but all for property stuff or business stuff. And yeah, I tried to steer away from anything that's family law, but property law, I think, was the way, and it's helping people build assets and grow what they're doing. So
it's meaty.
Just found it something. Yeah.
Yeah.
And it was always cut and dry. So it was always just not much emotion to it, helping people build assets, build wealth. So
did you specifically study or specialize in property law at uni?
So at uni, you don't really specialize in anything. They teach you everything, and then you make a decision as to what you want to do with after uni. And I started off in tax, and that was too dry for me. So and then I moved over to property after doing that for a year and never looked back.
Tracked it down. Yeah. Lawyers are, and for those of you who know me, know I knock around law a fair bit, and I know lawyers pretty well. I know the business of law pretty well, and when I use a term of phrase like the business of law, I get pulled up by lawyers very, very quickly, and they remind me that it's a profession.
Yeah, that's right.
And they're quite sort of a bit sensitive around that.
I'm not as sensitive as others, but I know that some.
It is a profession. It's like medicine, right?
Absolutely.
Accounting is a profession. Medicine is a profession.
Yep.
Law is a profession, and lawyers operate under a specific sort of code of conduct to represent their clients and confidentiality. Also, supposed to give back a bit with some pro bono and all that sort of thing. Do you get stuck into that sort of thing as well? Yeah,
we do a few pro bono matters here and there to keep us above that line and make sure that we're doing the right thing by people. But it is a profession, and there's so much to lose if you do something wrong in the profession. You work so hard. You've got 5 years of practice. You've got everything else that you build in terms of experience, and it could be one line that you cross and you lose it all, and there's no coming back.
The best lawyers I know are able to take very good briefs from their clients and operate on that way. So make sure you have a good working relationship with your lawyers, and it should be bound in trust, and tell them what you want, and they'll work out a way to get there. But this is around property law, and no doubt there's a lot of connected aspects of it. Tell us about Rethink. It's been around for a little while, Rethink Property Lawyers. What's the backstory to the firm?
Yeah, so I met Scott probably over 10 years ago. Scott actually went to school with me, but he was a couple of years older than me. So we weren't acquainted at school, but I met Scott just over 10 years ago, and he was just getting Rethink off the ground. At the time, it was residential. And then we hit it off, and he started referring me on some clients from what he was doing of the residential stuff, and that grew quite quickly. And then I was doing all of Scott's personal work as well. And after that, he moved into the commercial space, and that blew out as well. And so we've been working together for 10 years, and then the whole Rethink branding opened up probably about 4 or 5 years ago, and having that under one banner. And we're still independent of Rethink Investing in terms of what we do and how we do everything, but it's all understanding each other's processes, how each business works, and making sure that the client gets the best, most streamlined service that they can as part of the process, because it is quite daunting. There's so much that you take in, especially if it's your first commercial property purchase. Very different to residential. Residential is emotions. How does this look? How does this feel? But commercial properties, numbers, does this work? Am I protected? Is this the safe purchase for me? So
you've sort of strategically put a firewall in between the sort of the buying and the legal side of things. So
absolutely,
it's not incumbent on the client. Doesn't have to use you guys. No, they've got their own law firms. They can.
Some clients have their own lawyers, and they engage that way. But most of the time, while we find it, we've got the experience across a number of states, but clients find that we've worked with Rethink Investing a lot of times and understand their processes. But what we execute in terms of legal is still what we have to do on any other transaction, whether a buyer's agent's involved or not. But having a buyer's agency that you work with closely allows you to build rapport, be able to talk about any issues that come up openly and address those issues together. Because sometimes you'll realize, Rethink Investing will have the relationships with the agents and be able to get into a vendor's ear about certain things or improve the way a deal moves forward, rather than having just lawyers communicate. Because sometimes lawyers can get loyally against each other, and sometimes all you need is have someone come in between and say, look, let's take a step back here. It's commercial. Do we want this to happen or not? And if so, then it works. And
this goes back to my earlier point. You want good lawyers in your corner, but commercially it doesn't really matter.
So, and some lawyers will jump into their client's shoes and almost want to make those commercial decisions for them as well, and that's when it gets dangerous. So we're trying to keep that line drawn. We're separate. We're independent. We're all here to protect the client, make sure the client has the best deal moving forward. And so that's what we're doing from a legal perspective, and that's what Rethink Investing is doing on their side.
So you mentioned that pretty much everyone knows a lawyer these days. Like all professions, not all lawyers are created equal. How do you know if you've got a decent lawyer when it comes to commercial property transactions? Because you don't want the wrong lawyer.
Yeah. Look, it's a tough question to prove to clients when you first bring them on board, but you only know after the fact whether you had a good lawyer or not.
Yeah.
Because if you don't, the issues come up later. And some people come up to me and they're quite they're quite cost conscious in terms of, am I paying too much for a lawyer, or a mate told me that, this lawyer is cheaper.
Yeah.
But the devil's in the detail, and it's when you come back and have to deal with a $50,000 issue down the track, or a $100,000 issue that you could have just had resolved earlier on and paid maybe $2,000 or $3,000 more in legal fees up front, then you realize the value of a good lawyer.
So for those of you who might not know, difference between a lawyer and a conveyancer when it comes to property transactions?
So conveyancers, they're to convey a property, transact it from one person to another. But a lawyer has the experience when it comes to legal issues, legal disputes, a lot more experience in various aspects of law. And so most of the time when things get too difficult for a conveyancer, they'll normally refer you back out to a lawyer and say, go see a lawyer about this.
And it can be an actual tangible upside in leveraging a good lawyer, because a lot of the value of what you're creating when you're buying commercial property is connected to the lease, and the lease will drive the value of it. A good lawyer will actually understand how to create value in the lease and get that structurally built into any assessment, but then also moving forward how it goes ahead.
Yeah, and like the lease is your cornerstone of everything you do, and having that watertight is really important. Sometimes there's things that we pick up in leases which are absolute deal breakers, and the normal eye probably wouldn't pick that up. So that's super important to get that right.
And it's also longer term protections and liabilities around it. And sort of before we get into the meat of the podcast, a couple of other terms that you probably need to get associated with, even if you're not legally orientated, is warranties and indemnities. Maybe just quickly explain what they are and the difference between them.
Yeah, so in every contract for sale, there's warranties and indemnities that are given by a vendor and a buyer as well. And when you've got those in a contract, it's basically who has the liability or who's got the ability to be liable for a situation that might arise. So some indemnities are given by vendors in terms of what they're providing in terms of the property. And in a lot of states, vendors will say, it's up to you to find out everything. But that's where a good lawyer comes in and makes sure that certain things are and remain the vendor's liability, as opposed to them being simply pushed to the purchaser when they're taking over a contract. So an indemnity liability is making sure that person indemnifies you as a buyer who's coming on board for anything that might go wrong in the future.
So they're essentially just promises between two people that what I've told
Correct.
you is accurate, and then what you're telling me I accept, and therefore if this happens, therefore we'll work it out. And then you've got the specifics of the lease, which drives valuations. And just to set us up a little bit at the front end, so how broad or how far will you and your team or a good property lawyer go into the mechanical aspects of that at a DD side of things? That's where you guys operate, but then also factoring out or planning for longer term lease sort of expansions.
So the due diligence period, I guess, is the most important period in any transaction. That's where a lot of the heavy lifting happens. And it's in that period where we go through the lease in a fine-tooth comb.
Yeah.
And some clients might come and say, well, this lease is 6 pages. Why am I paying so much money to have this? But you're paying for the experience of picking up the things that are not there. It's the silence in the contracts that are important, which an experienced lawyer will be able to know this is what's missing. It's easy for someone to review something that's already there, but it's what's not there is that often kills buyers and leases that are not available. That's where we go through everything in detail, whether it's your lease terms, your outgoings, your make good clauses, your rent reviews, how do they happen, make sure you're protected, your options. So all that stuff is very important in reviewing the lease. And
then there's also an overlay which is more compliance orientated around sort of environmental issues and really understanding, the mechanics of the building, cladding issues, asbestos issues. Like a good lawyer will look at all those things for you.
So as part of that process, when Rethink Investing does a lot of the building and pest or strata searches, they'll pick up a lot of things. But we also do a number of searches on properties, a number of detailed searches, which are sometimes expensive for clients. But once again, it goes back to that principle of pay a bit extra now, but make sure you've got that issue identified later. And things like outstanding notices on properties, environmental issues, flooding issues, bushfire risks, potential contamination. Sometimes we've had sites where there's been previous petrol stations on there, and they're usually contaminated for a significant period of time, even after being removed. So clients need to understand that. So we pick up a lot of those things as part of our due diligence and making sure that you don't buy this property and then after exchange a year or 2 years later, you're up for 200, 300, 400K for something that you could have picked up with a $600-700 search.
So back to the structural mechanics of it all. So you work with the Rethink crew on providing sort of DD and legal services connected with it, but it's not incumbent on using Rethink as a buyer's agent in order to leverage your skills and capabilities. Like me, if I'm buying stuff personally, I can go to you.
Yep.
Can you act for me on this?
Absolutely. So we're just an added service for Rethink as part of the Rethink group for the Rethink investing component. Whether you want to get a will after it, or have a lease renewal, or buying a property on your own, or buying a residential property, we have the experience to do that. You're buying a business, we can help with all of that. So anything property, commercial focused, we can definitely assist. And we still provide the same level of service, the same level of detail. Everything's above line there.
So I'd call you up and go, hey, I'm going to put an offer in on this.
Yep.
Will you start acting for me from that point? Will you do pre-purchase DD for me to make sure?
Yep.
Okay, so step it out for me. Where's it start and where's it end?
Yeah, sure. So most people will come to us when they've found a property. You got your finance approved. That should all be sorted, ready to go. Sometimes people have structures ready. Sometimes people don't have structures ready. So if they don't, sometimes we provide that structuring advice to people. When we need to provide that structuring advice, it's, do you buy it in a trust? Do you buy it in your personal names? Do you put it in a company? How else do you structure it? Some people have certain things they want to achieve with kids and so on down the future in the track. So we can give you that advice separately. If you want that, I'd probably say give yourself a little bit more time in terms of the due diligence, because sometimes it can take some time to get those structures set up. Once that happens and you found a property and it's the right property, there'll be a contract for sale ready by the agent. Yep. Most of the time, they won't go on the market without a contract for sale. As soon as that contract comes to us, we'll say to the client, here's the fees, this is the process, quick summary. Then we get the green light. There's two ways a commercial property goes. One, it can be going to auction or has to be a quick sale. So you need to do all of your due diligence before the contract purchases. But 99% of the time for transactions we do the Rethink, it's you get a due diligence period for say 21 days, 14 days, 28 days. And if it's a hot market, which most of the time it is in Australia, we get a good due diligence clause in there, signed up for the client, and we say, look, during that DD period, we can go through everything in detail. As long as you've got that watertight DD clause that's in your contract, then the rest flows.
So you'll advise the client on the basis of the contract the contract negotiation to factor that in.
Correct. Yep. And we'll say, here's the clause that we recommend. Use it in your contract, and that clause will normally allow you to get out for any reason. We try to get clients out for no reason at all. You might get cold feet. You might say, look, my funding's changed, or I can't sell this property. So we make sure there's a DD clause that's protective for the client. And then once that's signed, if we sign the contract with that clause, then during that period, the 21 days, we go through everything in detail. You get advice on the lease and what's involved in the lease. You get advice on searches, everything that's involved in the searches, what's in the contract.
So searches being what?
Flood searches,
yep.
Bushfire, searches on tenants, searches on the landlord in terms of their companies or their assets. Is there any bankruptcy? Do they have any court proceedings? Title searches, environmental issues. There's planning certificates that we sometimes obtain depending on which state you're in.
So you'll check like zoning requirements.
Zoning, all of that.
Yeah.
Is there any charges that are on the property? So is there any outstanding notices? Does the council have an order against a property that says there's a non-compliant building on there?
Yeah.
So if any of that's showing, that'll pop up in our searches. And we give clients a detailed list.
And if there's any sort of contingent other finance connected with it, you'll find that. If it's just not with the bank, if it's other.
Yep. If there's PPSRs, secured assets on anything of the properties, we'll do a PPSR search as well. So make sure we identify if there's any securities. Sometimes, for example, once we found a crane on a property that was owned by a bank in terms of mortgage, client thought it was sold by the vendor with nothing being encumbered. So that was an essential part of the tenant operating their business, and so part of the rent, and we had to make sure that that was cleared before settlement, and that came over to our client as well. So they're the things you can pick up in your detailed searches, and so searches are getting more and more this
is pre the actual sale. This is pre
actual sale.
Yeah, so we're in DD.
You're in DD period.
Yeah.
So, but like I said, 99% of the time with Rethink investing deals, it's during that due diligence period. You'll sign a contract, and it could be in that period that you do it, or if you're a client that's not coming through Rethink, you do all of this before.
So your preference would be to get involved in the front end, not okay, I've already got a contract signed.
Definitely don't want a contract signed.
Yeah, okay.
Don't sign a contract without speaking to a lawyer, because you don't know what you're going to be in for. Some people even sign heads of agreements that they say, oh, it's just a letter of offer, and the agent said to me it's just a quick offer, but the devil's in the detail there. You'll be surprised you could be on the hook for a deposit that you lose if you choose not to go ahead, or there's no exclusivity for you as a buyer.
So in between the finding and actual signing of a contract phase, there might be this heads of agreement. So this is pretty common in not only commercial sales transaction, but also commercial leasing transactions. So essentially you negotiate and you write down a piece of things saying, hey, this is what we agree.
Yep.
But you're saying that sometimes that can be legally binding.
Yep. Absolutely. So it's one line in some of those agreements where it will say it's legally binding or it's not binding. And there's certain parts of heads agreements that are always going to be binding depending on how it's drafted. But things like exclusivity is what you want binding in those terms, because you haven't seen a contract for sale yet. So you don't want to be locked in. And the amount of times that clients have almost signed where it says the deposit's non-refundable is crazy.
So in between, and I'm just drawing, because I'm a very linear sort of guy, drawing out this step, so it just gives some structure to the chat. So I've found a property. So before we get in between finding it and signing a contract, there's this assessment bit that takes place. You're saying that you'll give advice to structure a contract up to give as much capacity as possible, be flexible to do the DD between a contract and a cooling off. That's where the bulk of the DD takes place. I've found a property and I want to get it to a contract, and there might be heads of agreement connected with it. How much advice will you give on whether or not it's a good property to buy? So this is where I'm just trying to get a lens of, a buyer's agent would say, this is really good because it's got X, Y, Z. It's going to grow in value. You've got this lease. It's going to be this, that, and the other. Like you don't provide advice on how good it is as a property itself. So this is important.
Yep. So there's a big difference between the commercial value of the entire property and all the numbers versus the legal components. So what the legal component is there to do is to make sure what you're being told you're being sold is correct. And so that's where the instructions that you were referring to earlier are really important for us as lawyers. And even though you might think something is not important, you'll be surprised how important it is when you tell us, because how much we can pick up from it. And we'll know to ask the right questions. And
I've always said when you're dealing with a lawyer or even a broker or a buyer's agent, you got to sometimes strip yourself bare, right? And if you're hiding stuff and you don't tell a lawyer or a broker, or they're compromised in their ability to provide you the right advice. So
correct.
You guys operate under confidentiality clauses, so just tell you, right?
Yeah. It's all privileged. Just tell us as much as you want, and we'll make a decision on what's important, what's not. But the more you tell us, the better. Because
I'm sure you found yourself in spots where you think you've negotiated a good deal, and something pops up, and you go, "Hey, you got to tell me this stuff." Right?
Clients like, "Oh, but I forgot to tell you this," and it's like, "This is a 180."
Signing a contract and a cooling off period is when the heavy DD goes on, and you're talking about all the searches, all the everything, zoning, etc. Can you actually can you use that period of time for you and your team or your lawyer to do feasibility studies on what is possible for this? So I go, well, I know the government is changing zoning maybe in 2 years' time, or this is happening and this is happening. Can you go to that depth and actually give a sense for what the future might look like, and therefore you can orientate your decision making around that? Yeah, so we don't give planning advice per se ourselves directly, but we do have lawyers that we can refer, because the planning sphere is completely different to what we do, and there's a lot more detail in that, and zoning advice, planning laws, development, so on and so forth. So we assist on going through developments, but planning advice is a specific area of law. So we won't give any feasibility on that, and I don't think you'll find that 21 days or 28 days is enough time for you to do a whole feasibility on a property. You've got to do that probably prior.
Got to do that before. And I think if anything, you should probably be looking at that before you go and sign a contract with us. When you're signing a 28-day due diligence clause, you've got to be ready to go, subject basically to your legals and your finance being unconditionally approved.
So this is the DD that happens pre-contract versus the DD that takes place post-contract.
That's right.
So if you're being ambitious about what can I do with this site, can I knock something down, can I build this on it, like that's all pre-contract. But you've got to be careful to avoid signing heads of agreement if it's too binding, because then you might find yourself at a stuck. But no doubt, I imagine a heads of agreement can be a really good tool to accelerate commercial discussions without commercially being bound to.
And it gives the agent comfort that you're willing to put your money where your mouth is to some extent. So, and most of the time agents will be happy with most of the amendments that we propose, provided they're not unreasonable. And most of our amendments are not. I mean, at the end of the day, I just want you to be able to get out if you find something that's curly. If you haven't signed a contract, you shouldn't have to go ahead, and you should be able to get your deposit back. But if an agent sees, okay, this guy's prepared to put down his $100,000 deposit for a heads of agreement, and he's willing to do his due diligence, then he must be a buyer that's definitely interested and not just calling a bluff.
How long does it take you guys to work out you're dealing with someone that's not as good as you on the other side? So if you're representing the buyer, pretty quickly the capabilities of the seller's lawyers.
Yep.
What's the sort of telltales that you're operating with people that aren't?
Look, we've been around for a while, so most of the lawyers that we know that are decent, we've dealt with before, and you come across them on a lot of deals.
So you want to deal with another decent lawyer on the other side?
Absolutely, and they know how you operate. You can pick up the phone, have a discussion with them, cut through all the things that are not necessary to be stuck on, and then work through the real important issues. You'll be surprised sometimes you'll see responses from lawyers that are inexperienced through ChatGPT responses, which is coming up more and more common, and it's clearly visible. But at the end of the day, we're not there to be combative, we're there to work with you. So when it comes to lawyers that are probably less experienced, we give a bit more detail on why we want certain things and how they should work. And so,
it could really slow down. I find it frustrating when, and I've done some transactions with less inexperienced lawyers on the other side, which is a bit complicated, and it's frustrating. Like, it slows everything down. You just sit there going, these guys just don't get it. You got to educate them on stuff, and when you got a non-lawyer like me, and I'm not a lawyer, having to educate people on the other side of you've got to look at these things, this, and you see their work coming back to you. It's sloppy. It's you know pretty quickly.
You'll see focus on things.
You look to exploit it, to be fair.
Yeah. You can sometimes, but you see that they focus on things that are not really important, and that's when the experience comes out.
Yeah,
and small clauses which are irrelevant, like they're going to be in every single contract, but that they're not an issue, and someone who's experienced will pick up on whether this is a deal breaker or not. So
you're doing your DD and you're satisfied with the outcomes of it all, and you pass your cooling off. That means your formal contract, which moves to settlement. So what happens between a cooling off and the settlement?
So usually after your due diligence, you reach your unconditional point. So from unconditional to settlement, it's about making sure any terms that you've agreed throughout that due diligence process are actually enforced or ready to go for settlement. Dealing with finance brokers and the banks to make sure that your finance is ready. Getting all your figures cleared up, making sure that any outstanding rates, taxes, levies, infrastructure charges, anything else that's on title, just cleared up. And make sure that anything you're taking over as a buyer is not encumbered from anyone else. So clear title, ready for your bank to take over. What does clear title mean?
I know lawyers throw those terms around, but this for Luddites like me, what's clear title mean?
Yeah, basically no loan from anyone else or anyone else having an interest in your property other than you. And normally when you take it over, most people have a bank. So the only person that should have an interest is your bank. And they have the first interest or first right to the property after you.
Where would your insurance stuff happen? Would that be taking place during that period of time to get all that?
So we normally push clients to get their insurances through due diligence period.
Okay.
Because let's just say, for example, you have a flooding issue. And then you find out insurance says, nope, sorry, we're not insuring your property.
So once you go conditional, you want to make sure
your insurance is right. And most of the time, or all the time, banks will say, I need a certificate of currency for your property. If you can't provide that, then your finance
simple thing. Also, you set the insurance up. You've probably got 21 days to pay the invoice anyway, so you can carry you through. And if it doesn't go ahead, you just bin it, right?
Move it. Correct.
Yeah. These are the little
tricks.
Little tricks. Okay, so it's important then between your unconditional and settlement. Is that when you start considering and thinking about drafting new leases and stuff like that? When does that sort of come into the?
So most of the time, leases are already entered into. For properties, unless you're going into a lease back arrangement where it's from a new developer. But most of the time, leases are already signed, and tenants are not going to negotiate any of those terms if they've already signed. And if we say, well, we want something to be fixed, we'll normally get it done. If it's the benefit of both parties, then it'll get done during that DD period. But the only time we start negotiating new leases is if leases are about to expire. we would jump in, and that normally happens after settlement. So there's not usually too much of that happening during the DD period.
Okay, but during the DD period, you're assessing the lease
Absolutely.
as well. So
Yes.
there's two things running in parallel, really. It's the
there's the contract,
Yep.
the searches that are happening, and the lease.
And the
so
lease.
they're the three things that we give advice on. Contract, making sure that's all above board. The searches, making sure they're all clear and no issues that come up. And the third thing is the leases, and making sure your lease is watertight, not too tenant favourable, and nothing that's curly in there for you as a future owner of the property that you have to be liable for.
And leases for, if you're new to commercial property, can be quite complicated and consuming, and you know, sometimes a lease is connected with several other documents. Leases might then have assignments of those leases or extensions of those leases, and then you also might have incentive deeds connected with that. So you can end up with 4 or 5 interconnected documents, which are all driven towards one central lease. So you guys pull all that apart and
correct,
make sure it's all good.
Yeah, and there's so many documents that can fundamentally change the original document. And if you're just given the original document, you might see 1/3 of the picture. But sometimes businesses or properties are sold throughout the way. Sometimes a landlord halfway through the transaction, for example, there was all those COVID reliefs that were given throughout the period, and landlords and tenants agreed numerous terms to amend leases throughout that process. So incentive deeds, you know, here's $500 off the top of your rent. And so some people might look at the lease and say, well, this lease says I'm getting $100K in rent a year. Why is it only 70? And you realize there's another document. They reach a different agreement. There's fit out works that the landlord's chosen to fund through a rental reduction. So all those things become visible from part of our review. And we ask all those questions from vendors.
This where it gets even, you know, cascading complexity of commercial property versus resi property. Like, you know, you end up in this situation where you argue who actually owns the fit out as part of this stuff, right? Like, you know, you got to uncover all that as part of it all. But importantly, with the lease, your sort of lease law really protects the income, and this is like, you know, well, what are the bits that actually move the net yield and valuation of a property that you've seen, or you've seen sort of most connected with these discussions?
So, biggest thing, ownership of items within a lease. For example, refrigeration in companies that have frozen foods. Who owns that? Is it the landlord? Is it the tenant? Who needs to maintain it? Landlord or tenant? Who owns certain things? For example, there was a property, as I said earlier, crane. Who owns that? Who needs to maintain it? Is it the tenant? It's for their use. And the other thing is outgoings. It's the biggest source of disputes between parties that we see in leases. Making sure your outgoings clauses are crystal clear is important, and in particular when it comes to retail leases. The biggest difference between residential property and commercial property is, in terms of leases, is commercial leases, every lawyer drafts their own. There's no template. There's no, this is the form that you should use. It's, this is what we've drafted. It works. And sometimes you'll be surprised how many times the drafting between the actual lease and what the Retail Leases Act allows are two different things. So sometimes you have a lease that says tenant pays land tax, but the retail legislation prevents it because it's a retail tenant. And if you don't know the retail legislation for every different state, you could think to yourself, if you had an experienced lawyer that says, says you can pay, the tenant's going to pay your land tax, but really they don't, or they're not allowed to. So that swings your yield hugely down the track.
And again, if you don't know, well, you don't know what you don't know, right? And there's so many, if you're not a lawyer and you're doing commercial real estate transactions, there is so many unknowns. And I've seen people fall foul of it. So how different would your work and the way you conduct this process be depending on the type of asset you're buying, whether it's industrial, retail, or office? Does it matter?
So the level of detail we go through is still the same across the board. But with retail assets, you need to understand a bit more about how the retail legislation affects leases. So if you don't know that, the retail aspect of it, you're going to miss a lot of things, especially in terms of recoverability of outgoings and what can landlords charge to tenants, what can't they? Could you have different land tax liabilities? That's another thing, depending on your structure in each state. Some people have certain trusts, special trusts that end up, when you buy the property from the vendor, because you hold it differently, your land tax liability the following year could be different. and it could go up from 5,000 to 15,000. But you would have done your yield numbers based on what's already being charged under the lease. So it's important you get that advice as well.
So how important is it, do you think, for buyers, irrespective of whether they're using buyer's agent or not, have a degree of familiarity with all these different concepts, and particularly with leases, like, you know, options, incentives, security instruments, like permitted use, make goods, you know, assignments and subleasing and stuff. Like, you can't just go, the lawyer will tell me what to do. You need to be able to integrate this, because this will pretty much move the needle whether it's a good or a bad deal.
Yeah, absolutely. And one of the biggest things that we realize with clients is some clients just jump in and expect you to cover absolutely everything. But there's a limited scope to what we can cover. And we take a lot of comfort when people come to us with a buyer's agent for commercial property, because there's so much that they cover that your layman buyer wouldn't know, or wouldn't know where to look. And it is those things such as planning, zoning. Is the tenant permitted to even operate in that premises? Have they got approvals? Are there building issues? What sort of building issues are there? So there's a lot of things which are commercial in nature. You need to have a vested involvement in the transaction, not just say lawyers will do everything, and even if you didn't have a buyer's agent, they'll tell me everything, because there's commercial numbers, there's rental ledgers that you need to look at. There's a number of things in the background that Rethink Investing will do as a buyer's agent, or any other buyer's agent should do for you, to make sure that it's commercially okay. Because in the legal side of things, we look at things in a different lens or a different perspective, and it's the making sure your contract's tight, your lease is tight, but is the tenant actually paying rent? We might not even have those ledgers. It could be a self-managed property. Rethink Investing looks at all that, or a buyer's agent should look at all that as well.
Yeah, how deep do you go with like building compliance and safety measures, you know, working out asbestos or cladding? You know, everyone's sort of heard all these cladding issues and whatnot, you know, fire systems, lifts. Like, you work out whether or not what's there is good and compliant.
Yep. So we do some searches that come up with things like asbestos. So there's asbestos registers that are available for properties, so we can identify all of that. A lot of these building issues or safety issues might come up in the building and pest report that's done for some properties. If it's a strata scheme or complex, it'll show up whether they have fire certificates. So we make sure that there's certain fire compliance certificates for all of those schemes. There's only so much that we can do because we haven't seen the property itself as well.
Yeah.
So we're given a contract. Every contract looks very similar to us. And there's only so much you can see from a Google search or how much is put onto an ad. What's important is a client either seeing the property or having someone look at it for them and make sure that it's compliant from all these things. And someone who's a building and pest inspector will be able to tell you if something looks non-compliant. A lot of people have valuers that even pick up, you know, they go through, there's a mezzanine level. Has this been approved? Comes to our attention, comes to the financier's attention. From the plans, no, it's not visible. We see a floor plan of what's actually on title of the contract, but if there's a second level that's been put in and no one's told us about it, it's impossible to identify. We ask the lawyers on the other side, are there any structures that are unapproved? If the vendor's aware, but how do you know the tenant hasn't installed it and not told you as an owner? So these are things you need to pick up along the way.
And so you'd work closely with the pest and building people as part of this process. That would take place during the sort of cooling off period, right?
Yeah, so they'll do their report. They'll come up with a list of things that they say are issues within the property. And then 9 times out of 10, the client will come to us and say, these are the issues that have come up. We need the vendor to fix them. And then we'll put conditions to the other side and make sure that it's watertight. Before settlement, make sure XYZ is fixed. Give us photos of these that they're fixed. Give us evidence that contractors have been paid. This is to avoid vendors just saying, yeah, I've done it, and send you a photo of a patch job, which might just cover your cracks and you think it's all done, but it really hasn't been done properly. So
these things happen.
Yeah.
These things certainly happen. And you spoke briefly about it, sort of securities finance and sort of PBSR. So these are registers where people take on incumbency with debt. It's registered, sometimes registered, sometimes not registered. So this is a key core tool for working out sort of, you know, exposure that might not be visible above the line.
Yeah, and sometimes we do PPSR searches and we pick up that there's interests from certain entities that are not shown on the mortgage. Like, for example, you might have NAB or Commonwealth Bank that have a loan over the property, and sometimes it's over the company as well. But then you'll realize there's another company that's come in as a security over the vendor, and so that shows up. And then you ask questions, why is there PPSR? And they say, there's actually a security over the fridges which we've bought for $100,000, and then you start asking more questions. So you can pick up a lot of things from the PPSR searches that we do, and make sure the titles are clear in that respect.
So that means that what you see and what you think you're buying, you actually own.
Correct.
The core thing. So does that go wrong often? Like that people just assume that, they buy at a cold storage warehouse and they think they're getting the freezers and stuff, and they go, no, man, we own that.
Yeah, correct.
Yeah.
And a lot of the time tenants will fight for that as well, because it's expensive stuff. And there has been instances where people thought they're buying something and they weren't, or they thought that it's the tenant's maintenance, but it's not theirs. And you realize sometimes maintenance for these things every, say, 3 or 5 years could be $100,000, $150,000. So that'll throw out your yield for the property or your returns on it. And it's costs that you don't know or you're not aware of that will come up later and sting you if you don't pick them up.
Do you see much argy-bargy when it comes to sort of fit-outs and this sort of stuff? Or if you cover it at the front end, you're normally okay?
If you cover it at the front end, you're okay. If you get a condition report, which is the most important thing, then you know what the property was in at the time you bought it. If you don't have a condition report, that's when you start having arguments about, what do I need to do for the fit out? Which condition am I returning it from? Which condition am I returning it to? People will say, well, I don't have photos of when I bought it 20 years ago. But going to be in trouble.
And this is the problem, right? A contract, you only need a contract when things normally go wrong. And you can sit there and just go, I can't be bothered doing the time, energy, and effort to go and get all the information prior. But when it happens, you need it. And trying to find it when you need it is often very, very difficult.
And the best type of contracts are the ones that you negotiate early, get them done, spend a lot of time going back and forth and know they're watertight, and put them at the bottom of your drawer, and hopefully you never have to get them out again. But when you do, you know that you did everything correctly up front.
So when you settle and you get the keys and it's your property, what's your involvement subsequent to that?
So what's really important when that happens, which a lot of people forget, is your bank guarantees, securities. That's your money that you have to protect yourself if something goes wrong with a tenant down the track. If it's a security deposit, gets adjusted on settlement, you get paid in your favour.
Maybe explain what security.
So there's types of securities. One is a security deposit bond. So it could be cash held by the old owner, which then gets given to you on settlement. Or the second type of security is a bank guarantee, which is basically a one-page document that outlines the amount of money that a bank has held on the tenant's behalf for you as the landlord if something goes wrong. And that most of the time is a piece of paper that's involved, or a piece of paper that is held in the old vendor's name. After settlement, you basically need, or your property manager should take that to the new tenant and say, this property's been sold now. We need a bank guarantee that's updated in our name. If you forget that and the tenant defaults down the track, you're going to have problems exercising your rights over that and getting your money.
So you'll help sort that out?
We'll help all sort that out. So we'll get the bank guarantee on settlement, give it to the agent, and ask the agent to liaise with the tenant, given they're one that they're going to have the relationship with after, and make sure that they get the security transferred over.
So in many ways, and a good lawyer will do this, a good lawyer will sort of buy you time and optionality is what I found the best, and that's what they do. What would you be concentrating on if you had to give away some of your sort of secret sauce? Like, what's the best way to buy optionality, you think, in a contract? The
best way is making sure your due diligence clause is as tight as possible when you go in. If you have a clause that, for example, automatically goes unconditional at a certain period of time. So there's deeming due diligence clauses and there's non-deeming clauses. If you have a deeming due diligence clause, you know you're under the clock, 21 days. If you don't get it in, it's unconditional automatically. And you could be at the pointy end of negotiations trying to get a couple of things over the line. If you've got that time racing against you, you might be left in a position where you've spent all this time, spent all this money, and then have to terminate a contract because you haven't been able to extend things with the vendor and work through it. So having a DD clause that's tight and allows you to work through anything that you need through that period, I think is super important and gives you so much option. Having the heads of agreement as well in your favor, making sure that it's not locking you in and losing money up front is super important.
So on the heads of agreement then, would you, obviously it's another tool that you can use to accelerate or decelerate or or get preconditions or contract to determine whether it's worth the time, energy, and effort to go down the pathway of a full assessment. Would you avoid using a heads of agreement if you could, or would you actually try and always structure one of them into a deal as long as it's in your favour?
If you could sign a contract with a good DD clause, I would say it's better to avoid a heads of agreement.
Okay.
If you have a heads of agreement and there's no other option, because I know there's some funds that's the only way they'll go forward with a particular buyer, and most of the time they'll give you the exclusivity anyway.
Yeah.
And they say, if you're happy, we'll give you all the documents through that period under the heads of agreement, and then you can go that way. So either way, doesn't really matter.
Doesn't matter.
But if you have a contract and that's a DD clause, it's better to go down that path.
And when you're sort of going through a heads of agreement type thing, you put the conditions precedents in them. So this is pretty much saying, hey, unless this is met, I'm out.
Yeah.
Right. So they can be a really good way for you to really control a deal.
Yeah, absolutely.
Yeah.
So things like options for finance, building and pest issues if they come up, making sure the contract is fine, making sure the lease meets certain terms, making sure there's certain rental amounts that are hit, and yields can sometimes be included in heads of agreement. But it's ultimately ticking off everything you've been told by the agent. So making sure that those things are covered off is very important.
And in relation to the lease, and we spoke about how that can be complicated or compounded by the fact that you might have a lease, but there's all this interconnected stuff. How important is the face rent on a lease when you're looking at these type of scenarios?
Yeah, I think it's really important for finance purposes. From our point of view, from a legal perspective, there's so many different ways as to how people structure rent. There's incentive deeds that are signed on the side that are put into place between parties so as to avoid any issues with face rent in the future. But face rent from a finance perspective is really important from our client's point of view, I guess. And
in relation to negotiating a deal, if you identify things through this process which are subpar or not satisfactory, which means there might be some sort of contingent cost in the future, you can negotiate that out during this period.
Yes.
So like if you do identify non-compliance matters, which translates into CapEx tomorrow, you can make sure you can get work done or ameliorate those things through this.
Absolutely. So I think that, the non-compliance today becomes the CapEx tomorrow is really important. And I feel like anything throughout this due diligence period, you can get corrected. And if you have a vendor that says, no, I'm not willing to make these changes, then that's a red flag in itself.
Yeah.
So just pick that up and know that this is the risk that you've got now. Either go forward or don't go forward. And that's why you have those periods. And there's sometimes things that we pick up where clients say, oh, I know I've spent 5 or 10 grand in legals, but if I didn't pick this up, it could have been a lot more than that.
What about sort of deeds of priority? So this is when stuff goes wrong. You want to make sure you get your dough first. Like, how do you factor that into sort of these discussions? Yeah,
the deeds of priority are probably a lot more important for banks because it gives them their security first before anyone else. And having deeds of priority in place ultimately outlines in simple terms who gets what first in the arrangement. So they don't come up quite a bit, but it depends on the state. Some banks require them to be signed for their finance purposes, but from a legal viewpoint, we don't go into that in too much detail.
And in relation to you said you started off being a tax lawyer and then you ended up a property lawyer. And again, this is where does the obligations and the services of a lawyer start and end? And no doubt there's probably an accountant involved in these things as well. But what have you seen in the past, like best structuring purchases to optimize tax and liability while ensuring that you keep your sort of financing serviceability pretty right? What works well?
Look, each deal or each transaction is very different. In terms of tax optimization, it is really important that you work with your accountant and your separate tax advisor. Some accountants will give tax advice on certain things, but some accountants won't. The tax advice component is important to get from a tax advisor because we won't give any advice on tax as lawyers. We're not specialist tax people, and that can be conflicting because we might say to a client, put your property in a company or in a trust. It'll protect you if anything else goes wrong from any of your other assets. But your accountant or tax advisor might say, I think it should be in your personal name because you'll get the CGT discount of 50% if you hold it for more than 12 months. So they're competing interests, but you need to know which one works best for your personal situation. And us as lawyers might not know that you have 6 other properties, 7 trusts, 4 children, and you've structured in a certain way. So your accountant is important and tax advisor in that process to get that right for you.
And it's about, therefore, lining up your advisors so they can
be all on the same page.
Yeah, and talk not independently of you, but combined, because you don't want everything coming back to you each time.
Correct. And one of the first things we say to clients when they get put through to us is speak to your accountant about the entity that's going to go on the contract, because that's the most important. That's where your duty. You can't come back to me later in 2 years' time and say, actually, I should have put it in a trust. Can I just update it? You're going to have stamp duty implications, capital gains tax, plenty of other tax issues.
So sometimes it's hard even to change it when you're in the process.
Yep.
Some lawyers will make it easy to change the entity name, but others will hold you to the...
Well, the biggest thing is stamp duty, right? So in that process, the minute you've signed a contract, Office of State Revenue will say, if you decide to change an entity throughout that period, why is there now a different entity on title? It'll flag up at their end very quickly. And if you don't have a proper explanation saying, we've rescinded this contract and we've got a new contract now and it's in the right entity, they'll say, oh, double stamp duty. And before you know it, 50 grand of stamp duty is now 100 or even more. So it's important you get it right.
Yeah, absolutely. And what do you see, which, you've done a lot of deals, which lease mechanics do you think most affect valuation and cash flow resilience when you look at a sort of the full period of holding a property?
Well, I think one of the biggest things that we find affect valuations are the leaseback arrangements on new developments. There's a few of those going around, and if they're not structured correctly, I think you can have a lot of problems with your financiers. And a lot of them can be done quite loosely, especially by lawyers that are not experienced in arranging leasebacks. You need to make sure you have the right protections for the buyer, the right securities in place to keep a vendor on the hook if after settlement they decide to shut shop and go somewhere, and make sure that you've got the right tenant that's in there, that's got the right securities, values, financial strength to be able to maintain and continue. And a lot of the time in those arrangements, if you don't get that right, financiers and valuers will say, this is not the right deal for us.
So obviously we're spoken mainly around acquiring property, but you act on both sides of the ledger. You act on behalf of the seller as well. So this question can swing both ways. I'll probably conclude with this. When you look at sort of pre-acquisition due diligence, what items most commonly derail settlement, as in getting away of making it happen, or trigger price adjustments? And you can always be looking for price adjustments as a buyer because you can use it as a mechanism for driving the price down, but you want to be buttressing that as a seller. So what are the key things?
Yeah, one of the biggest things that we find drives prices down, and there's mostly price adjustments, is the yields and the rental outgoings that are payable on a property.
Okay.
Clients think they're being told this is a triple net lease.
So explain triple net lease. Everyone sort of throws those terms around.
So basically it's a lease where all outgoings are paid, including your land tax as well. So the land tax is the key component, and all of the council rates and everything else, including management fees and so on and so forth. So it's everything that's under the lease that's being paid. Sometimes leases are not triple net and land tax is not recoverable, and that becomes payable by the vendor because the Retail Leases Act excludes it, even though the lease already says, yep, land tax is included. And an agent might think, it's the lease says it's all outgoings included, but you quickly realize it's not. And that changes your yield, which then in turn leads to a price adjustment, price reduction, so on and so forth to correct it. And 8 times out of 10, the vendor will say, okay, you know what, you're right, it's being sold to you on this basis. We'll give you a price adjustment to meet the needs because you're told X and it's actually Y.
Do you actively go and chase holes in deals so you can drive price down? Is that or at least provide those recommendations to help drive the price down?
No, we don't really actively look for it, but we know the things that we need to identify. And in your advice, you'll see in bold, this is the thing that's missing, or just letting you know, base outgoings. It says on the front page, 100% of outgoings. Then you go to look at the definition of outgoings and it says 100% of over a base year of 2024. So we had a client that thought that was the case in a shopping center lease, and all the leases were base year above 2024. So instead of thinking they were getting $30,000 worth of outgoings payable, it was actually $2,000. That's because of the base of outgoings and the definition, and that's what it said. And looking at the front page, to the inexperienced eye, looks like I'm paying outgoings in full, but the reality is
You still doing deals yourself? Are you still reading contracts, or are you mainly just sort of organising the business these days?
No, I'm organising the business.
Yeah.
But sometimes clients will specifically ask for me to help out, and I'm still there. I'm supervising all of it across the entire team.
Yeah.
So we've got close to 25 people within the team that are working.
Good lawyers.
Good lawyers.
Yeah.
Been trained well, hopefully.
Yeah, I think so.
And
I don't know how you guys do it. Unfortunately, in my job, I have to look at a lot of legal contracts, and I just sit there just going, I'm so happy I never chose law.
Yeah.
I wasn't smart enough to be fair, but I'm so happy. I'm so happy I didn't choose law. And the point there is that you've got to be wired a particular way to do that well.
Yeah, absolutely.
And good lawyers, they have passion for it. They drive.
They do. Look, I've got a great team behind me, and that's what's important. And that's what allows all of this to happen.
Yeah.
There's no way I'd be able to do this by myself. It's just the amount of work, the amount that's involved, the amount of moving parts. But the value that you get out of lawyers, once a person said to me, well, why are you charging me $700 for an hour of your time? Like, where's the value in that? I can just pick up the phone and you can answer it for me.
Yeah.
But it's the 10 or 15 years of experience that's allowed me to answer that question in 5 minutes is what you're paying for, as opposed to someone who's not experienced in that space and takes 3 days to come back to you, doesn't have the experience. That's where the value is.
That's the irony of a good lawyer and good legal work being done, because once a deal is done, you never really acknowledge that it's been pain-free subsequent to it. It's because the hard work's gone on the front end. So
Absolutely.
In many ways, it's really unloved and it's unrealised, the value of really quality legal work, because you have no problems after it. It's because of what's happened in the front.
Yeah, or throughout the process. Some people will just say, well, like, we didn't really hear much from you. Like, why is this so expensive? But the reason why you've not heard much is because everything's been dealt with behind the scenes. If I copied you into every single email, every single call that we had, and you'd lose your mind for the amount of communication there is.
You don't have to tell me you don't want to do it. You don't want to do it. But no, it's really important. It's good we can have this chat, Sam. Everyone gets so excited about sort of where you're buying and what the yields are and cap rates and all this sort of stuff and how much money you're going to make out of it. But this is the real functional important aspect of buying and holding commercial property, right?
Yeah.
Like it is really legally orientated, and big dollars floating around, and people are bound by certain things. They're going to make sure everything stacks up. So thanks for coming in, mate.
You're welcome. Thank you very much for having me.
I tried to sort of put it into a layman's discussion as much as possible, because that's how I need to do things myself to understand it. But hopefully we've reinforced just how important this aspect is, and the need for a good lawyer, rather a good property lawyer.
Thank you.
Yeah, rather than just a lawyer who does suburban divorces and stuff, right? Two very different things.
They're very different, and I think, as I said, it's the biggest transaction of your life for most people, and spending the right money on that to make sure that transaction's right, I think is
cool.
Is definitely worth it.
Well, I'm working on something right now. I'll give you a call. I'll give you. I want you to do it yourself. See what I did there, everyone. Yeah, it was really good. But go and track down the team. Rethink Property Lawyers. Just Google it. You'll be able to find them. And even it's just really a prelim thing, right? Like, you're happy to have a chat with people. Say, hey, I'm doing this, and
this is where I'm heading, and this is what will tell you what you can expect, and give you some information around that.
Brilliant.
And that way, when you're ready and you found something, you can hit the floor running.
All right, nice one. Hope you enjoyed that, everyone. Thanks for tuning in. This is Inside Commercial Property. We'll be back again next month with more of this. Until then, I'll see you later. Bye-bye.